We got everybody. Okay. This case and the next case are kind of out of the same, they're essentially cross appeals or could have been cross appeals. And my question is would you rather argue them separately or would you rather proceed as if they were cross appeals? And I'll give you a little extra time to do that if you wish.
I have no preference, Your Honor. I can argue them both at the same time.
That's the same for me, Your Honor.
Okay, well then let's proceed. Why don't I give you like an extra, I don't know, 10 minutes? And would that be enough? And so 5 on each side. Does that work? And
More than enough, Your Honor.
Yes,
Okay.
Your Honor.
so we will proceed as if the second case is a cross appeal from the first case. All right, Mr. Wallen, you're up.
All right, good morning. May it please the court. Todd Wallen on behalf of OTI Fiber. I'd like to reserve 5 or 7 minutes for rebuttal. I don't think I'll need it.
Right.
Well, this case stems from an order that essentially requires OTI to pay for equipment that it has no use for, that has no value to it. And it's being required to do so pursuant to a asset purchase agreement, which is a agreement to purchase assets from FFN, to which CenterState is not a party. And the claim here is an unspecific claim to recover money damages. The claim doesn't set forth what the cause of action is. But the law in Florida is clear. The only way, the allegation here is that OTI promised to make payments to CenterState in the APA. But the plaintiff CenterState doesn't allege that it has a right to enforce that promise in the APA. It doesn't allege that that OTI breached any provision of the APA. Instead, they skipped to the note to which OTI is not a party and said we breached the note. That is not a cause of action. The cause of action has to be as a third-party beneficiary to the promise who's entitled to enforce the promise. And it just wasn't pled in this case. We asserted it as an affirmative defense. And on that ground alone, the CenterState did not meet its burden refuting all of the affirmative defenses because it simply hasn't pled a cause of action in this case. I still don't know what the cause of action is. There's several other reasons that reversal is warranted here. And the fact that the trial court didn't even address the failure to state a cause of action affirmative defense and didn't even address other affirmative defenses, such as our defense that the APA should not be enforced based upon misconduct by the other contracting party, FFN. The order says nothing about these things. Frankly, CenterState didn't argue them in their summary judgment motion. And the law in Florida is clear, and we've cited several of the cases, including one out of this court, the Board of Trustees versus Schindler, 604 Southern 2nd 569. Along with Herchella, which is a 4th DCA case, Wendt, which is a 5th DCA case, that if a trial court just skips over affirmative defenses, it's reversible error. The court has to send it back to evaluate whether or not those defenses have a basis. So on that second ground, that's 2 grounds for reversal right there. Now, there's a third ground. The only affirmative defense that the trial court actually appears to have addressed is OTI's defense that it received, that the contract, the APA is not enforceable, at least the provisions concerning this collateral are not enforceable because it received no consideration in return for the promise to pay the debt that FFN had to CenterState. And the evidence of that obviously was Mr. Bustamantes's affidavit that he said, look, we took this collateral essentially for a test drive. We've determined that it was not suitable for purpose. It was not in good working order. We had to purchase all new equipment to perform the services that we were acquiring the rights to. And we tried to return this equipment. What the trial court did, though, was it didn't view this as a simple transaction where the consideration for the promise to pay the debt was the actual collateral that we were supposedly purchasing. Instead, it viewed it as something out of, I think it's section 2.5B of the APA, which just recognizes that if OTI is going to pay a third party for the collateral, pay off the debt, it doesn't have to pay FFN as well for the collateral. That's not consideration. That's just a recognition that we don't have to pay for it twice. The consideration.
Mr. Wallen,
yes.
even assuming that that's true, and I think that argument is well taken.
Mhm.
Even assuming that's true, do we look at that provision in isolation, or do we look at it as part of the whole APA and say, well, the consideration for that provision, that's part of the larger agreement. And so the consideration is that they entered into this agreement and they got all the other things in conjunction with, it's not just about the collateral.
Well, true. You always have to look at the contract as a whole and not just isolated provisions that are cherry picked. But the entire agreement is an agreement to acquire A, equipment, and B, servicing rights in return for payment of money. The specific equipment that we're talking about here had a price tag on it under that agreement, and the agreement specifically said that OTI hasn't had a chance to even evaluate whether or not that price is worth paying. And the agreement lays out other provisions that allow OTI to, over a period of time, evaluate it. If the representations and warranties that are made in 3.5 of the agreement are not true, paragraph 9.13 allows us to withhold payment and not make payment for the collateral. There's another provision, I think it's in section 8, that allows us to just terminate the agreement if the representations are not as FFN made them out to seem.
So seems pretty clear that the judge actually didn't treat this as a third party beneficiary claim, but more as if you had directly assumed the original obligation.
Well,
basically, I mean,
the judge treated it as if we were
how to
improving.
explain skipping all of these provisions in the APA as you're complaining of, right? I mean, the project proceeded in this order proceeds as if you had come in and signed the note.
Exactly. Treated us as if we were in privity of contract with Center State, and not as if we had signed a completely separate agreement and Center State had to establish a right to enforce it.
The Center State was not party to.
Correct. Center State was not a party to that agreement, nor was its predecessor, Sunshine Bank. So that's where the court, I think, erred. Instead of viewing this as something that Center State's coming in and trying to enforce a promise in the APA, and well, how can it do that? It didn't ask that question. It just skipped over it and treated us as if we were a party to the note. The law is clear. We can't be held liable on a contract that we're not in privity to. So what we've got here is there's no cause of action, no valid cause of action that's asserted. The court didn't address at least 2 of the affirmative defenses, which is clear reversible error. And then for the third affirmative defense, which is we didn't receive any consideration, the court came up with a view of consideration that's taken from paragraph 2.5B of the APA that Center State never argued in its summary judgment motion. We never had an opportunity to address that. The law is also clear, and we cited the 4th DCA case, the State Farm versus Figler, 189 Southern 3rd 970, and a decision out of this court, HSBC versus Mullen, 159 Southern 3rd 250, that where an argument is not specifically made for summary judgment, a trial court errs in adopting an argument that wasn't made and wasn't presented in the motion. That's a third ground for reversal right there. Now, I also want to say that there's, even if they could get past all of that, there are multiple disputes or issues of material fact that are disputed. And, one obviously is whether the APA is enforceable due to a lack of consideration. The second is whether the APA is enforceable due to FFN's misrepresentations about the equipment that was being provided. And third, even if the APA is enforceable by CenterState, the issue is there's an issue of fact as to whether it represented anything but a conditional agreement to purchase it in the future if the representations turned out to be true. Now, CenterState does not even argue in their briefs that the collateral at issue here had value. The evidence is undisputed on that point from Mr. Bustamantes's affidavit that it did not, that we are now being held to being required to pay for something that has no value. There's no dispute about that. In fact, on this record, had we moved for summary judgment, we'd be entitled to judgment. On the second issue as to whether the APA was enforceable due to FFN's misrepresentations, the CenterState really just quibbles with the fact that it's titled equitable estoppel and that the affirmative defense isn't clear. But that's something that needed to be hashed out in a motion for clarification, a motion to strike the affirmative defense. It's not appropriate on summary judgment. And there's a case, Smith versus Reeder, 371, Southern 2nd, 718, 3rd DCA case, 1979, that lack of clarity in a pleading is not a basis for summary judgment. They need to get the clarity. They don't get to just come in and say, I don't understand, therefore we're entitled to summary judgment. The allegations themselves in the affirmative defense pretty clearly state that OTI relied on FFN's conduct in good faith, and that the conduct was such that it precludes plaintiff from asserting rights of contract against OTI. I mean, call it fraudulent inducement, call it what you want. It is a valid point that the APA can't be enforced if FFN made material misrepresentations about the collateral. And that's exactly what Mr. Bustamante specified in his affidavit, and is exactly why there is no dispute of fact on that issue in our favor.
Mr. Rowland, how would you respond to the suggestion that one or more of the affirmative defenses were not fleshed out with allegations of fact?
Well, I think that's a motion that needs to be filed at the pleading stage and before summary judgment. You don't get to just come in and say.
You would suggest that the complaint about the sufficiency of the pleading of the affirmative defenses was waived.
Well, it's waived for summary judgment purposes, yes. I mean, they could go back and, if this gets sent back, they could file their motion for clarification at any time. I mean,
or to strike.
Yeah, or to strike. It could be cleared up. And had they done that, we would have had an opportunity to plead it. But, the law out of this district, and we cited Synaxis Land Company versus Hunt, 315 Southern 3rd, 130. I'm sorry, it's not this district, it's the third recent case. But the movement on summary judgment has to, quote, overcome all reasonable inferences which may be drawn in favor of the opposing party. And if there is, quote, the possibility of any issue of material fact, or if the record raises even the slightest doubt, summary judgment is improper. They didn't flush out this defense. They didn't prove that there's no way we can prevail on this defense. And therefore they haven't met their burden. And we've got an additional problem in this regard, in that there are pending cross claims between FFN and OTI to rescind the APA altogether because of these sorts of misrepresentations in the agreement. And what we're running the risk of now is that we're going to have a judgment enforcing the APA for a third party and saying, yeah, it's enforceable and you've got to pay on it. And then they may come back later after a trial and say, no, the APA is not enforceable. How does that make sense? Those are inconsistent judgments. And it's something that this should not have been resolved without resolving that other claim.
Okay, you are down to 7 minutes. I don't know how much you want to say for rebuttal on.
Okay, I'd like to continue, but
I'll speak up again at 5. How's that?
Okay. And the third issue of fact is whether or not this was, and I touched on this before, whether or not this was anything but a contingent agreement to purchase the assets once the test drive has been taken. And there is evidence of that in the record. Mr. Bustamante testified to it in his affidavit. Section 2.5C of the APA recognizes that the valuation of this equipment has not been assessed, and we don't know whether it's got any value. 3.5 of the APA is a warranty by FFN that it's in good working order and suitable for the services that we're intended to provide.
Well, let me ask you something about that, Mr. Wallen. Was that
Mhm.
applicable before closing, or did that continue?
It continued after, because the fact of the matter is they wanted to rush to closing, and the intent behind this was well, we're going to assess the equipment after we receive it and after it's closed, but it's not something that we've got a deadline under the APA to assert these rights under rights to terminate the agreement or right under 9.13 to withhold payment and not make payment. So even after closing, we've got a right to say, no, this equipment is worthless. And that's exactly what we did. And we're not making payment on it. That is a conditional agreement. But there's another provision, which is 7.1 of the APA, requires FFN to provide a bill of sale and assignment of the assets to OTI. There is no evidence in the record that that was ever done. And the APA needs to be viewed as an agreement to purchase the stuff in the future. Until there's a bill of sale and proof that the assignment has been, and a separate assignment has been made, it hasn't been done. And not only is there no evidence in the record that those things were done, FFN's own loan documents with Center State, well, with Sunshine, preclude them from selling the collateral without written consent. So any one of these things.
Now you're at 5 minutes, Mr. Wallen. So.
Okay. And I just want to quote the Chabra case versus Morales. It's 906 SO Southern 2nd, 1261 out of the 4th DCA. And it's, quote, when the terms of a written agreement are disputed and rationally susceptible to more than one construction, an issue of fact is presented which cannot properly be resolved on summary judgment. That's exactly what we've got here. Any one of those 4 pieces of evidence would be sufficient to say, hey, this agreement is not a final agreement to acquire this property, and this needs to go to further discovery and maybe be addressed later. But that's what happens here. I mean, this summary judgment was filed very soon. Not a single deposition was taken. No one has testified as the intent of the parties in drafting the APA. The only thing that Center State's relied upon is an unverified interrogatory answer by FFN that has no legal effect. It's just premature at best. And
that's not the only thing that Center State relied on. There was also the fact that OTI made a number of payments.
True. OTI made a number of payments, and that there was no express, acknowledgement by OTI that it was assuming liability for the whole debt, though. I mean, they expressly said they'll take over, they'll take it for a test drive. They made payments. They didn't have an obligation to, but it's not something that Center State did in reliance on it, and therefore, we're somehow stopped because they relied upon it. They didn't rely upon anything. In fact, they sued, claiming that there was a breach of the agreement if FFN sold the assets to us. They literally alleged that. We also have one other argument that the affidavit itself was by someone who has no personal knowledge of the APA and completely insufficient with conclusions of law. I'll rest on the briefs for that one and reserve whatever time I've got left.
You have about 2.5 minutes.
Okay, thank you.
Okay, Ms. Fiore.
Good morning, Your Honors. May it please the court, I'm Kristen Fiore here today on behalf of Appalachia Center State Bank. I'm not sure how the different appeals will work, but I'd like to reserve a few minutes if necessary for the cross appeal. Oh.
That's exactly how it works. You would reserve time for your rebuttal on your cross appeal. So however much you want to do that.
Okay, maybe 3 minutes is fine.
Sure.
Your Honors, there's a lot I want to respond to in OTI's argument, but I do want to focus the court on the language of the agreement in question that shows exactly what OTI agreed to do in this case. If you look at section 2.3A of the agreement, which is at record 600, OTI, and if you'll permit me to just read the sentence, agreed to, quote, assume, pay, discharge, and perform several, quote, assumed obligations and liabilities. Those, quote, assumed obligations and liabilities explicitly included the loan from CenterState to Florida Fiber.
Now,
as
you would
shown-
agree that your client is entitled to enforce that only as a third-party beneficiary, correct?
So I agree that, and we addressed this in the briefs, but I agree that our client is under one theory, a third-party beneficiary to this agreement.
I would suggest perhaps, and I guess the question I'm asking you is, isn't that the only theory by which your client can enforce an agreement to which it is not, in fact, a party?
Well, I believe that if you look at the case law from, like, for example, the it's hard to pronounce, Ficosa case from the 3rd District Court of Appeals cited in our briefs, we can proceed under a contract theory because there is a privity of contract when an obligation exists towards another party as an assignee of an agreement. There's also the Bernard case from the Florida Supreme Court in 1982 that says a successor entity can be liable if it impliedly or expressly assumes liability. And so we proceeding on that theory, but under either a third party beneficiary.
And this is the theory that you pleaded in your complaint and on
Correct.
which you moved for summary judgment?
Yes, Your Honor. We brought an action for money damages against OTI and said that OTI has acknowledged the existence and authenticity of the APA. When it executed it, it expressly or impliedly assumed Florida Fiber's obligations under the note. This is at page 192 of the record. It then ratified those obligations when it made payments under the loan for 10 months. And then it breached the note by failing to continue to make those payments. There's nothing conditional about the assumption. If you look at the agreement, the asset purchase agreement created a method. If you look carefully at 2.5, and admittedly, there's a lot to unpack in the asset purchase agreement. But if you look at 2.5 B through D, you'll see that the agreement created a method to adjust the outstanding balance of the purchase price between OTI and Florida Fiber if there was something wrong with the collateral. But that would merely result in a price adjustment of what OTI was paying to Florida Fiber. There was no such provision regarding the bank. And if you look back at 2.3A, perform means perform, not some of the obligations, but all of the obligations. And I do want to address a few things that OTI said in its argument. Its argument regarding the court not addressing affirmative defenses in its order, that as a procedural note, that specific argument is raised for the first time in the reply brief. So we have an opportunity to respond to that. And OTI did not, when it received the summary judgment order, ask for rehearing on that basis, that the court didn't explicitly address the affirmative defenses. In any event, if you read those cases carefully.
Well, isn't that your obligation initially as a movement for summary judgment?
Yes, and that's what I was just about to
and
say.
Until you meet your burden of establishing your prima facie entitlement, generally the case law holds that the non-movement doesn't have to come forward with anything, correct?
Yes, Your Honor, but I'm referring to their argument that the court itself did not explicitly.
The court itself didn't address them because you don't seem to have addressed to overcome their affirmative defenses, correct?
Well, at first they argue that we have never we waived any argument regarding the specificity of their affirmative defenses. And if you look at page 550 of the record, which is our motion for summary judgment, we did in fact say that the affirmative defenses first do not preclude summary judgment because they're devoid of any specific factual.
But you had not previously moved to strike them or move for a more definite statement as to those affirmative defenses, correct?
Well, as to
or had you filed a response to the affirmative defenses? Like deny.
I honestly, I'm not sure. I don't recall. Yeah. However, I will tell you that regarding the failure to state a cause of action, while it's obviously a different standard, that had been disposed of previously by the court on a motion to dismiss. I did go through the elements of what we alleged in the complaint regarding the cause of action. Regarding the equitable estoppel claim, I mean, that the council has, or not council, OTI has changed a theory on us. It's now fraudulent inducement on appeal. And we cannot be expected to refute an affirmative defense that was never raised. Equitable estoppel is different than fraudulent inducement, even though equitable estoppel may have some sort of an element of fraud. And we do know that fraud must be pled with specificity. Now, regarding
let me come back to the failure to state a cause of action.
Yes, Your Honor.
So they file a motion to dismiss for failure to state a cause of action. It's
Correct.
denied, right?
Yes,
And then they assert it as an affirmative defense.
correct.
And your side says, well, Judge, you've already dealt with that.
Mhm.
Don't we get to review that for whether it's correct or not?
Yes, Your Honor. I mean, it can be raised again.
No, that's not really an answer to the issue of whether it was a proper summary judgment to say whether the court had previously denied a motion to dismiss.
Correct. That's just additional support. I agree with you, Your Honor. That alone is not a sufficient basis. However,
I wonder whether it's support at all. The question is whether that's a correct ruling, whether on a motion to dismiss or in a summary judgment.
whether it's a correct ruling that the failed to state a cause of action.
Correct.
We submit that in our summary judgment motion and with the affidavit of Mr. Hill that submitted, that authenticated the documents, that under a theory of assumption, which if you look at the case law on privity of contract does result where a party assumes obligations of a first party to an agreement, that there can be a cause of action for a breach of that agreement. And that's what we would say on the failure to state a cause of action. Now, on the consideration issue, I do want to point out that it was raised in the summary judgment motion. The law does not require that the law does not require the court to not, doesn't forbid the court from adding an additional basis of consideration there was a consideration under the plain language of the APA that OTI received a reduction in the purchase price of the collateral in addition to receiving the collateral period. And so their consideration, and also we argue that OTI is prevented from raising lack of consideration, because if you look at page 773 of the record, in their, if you'll permit me, it's on 773, in OTI's amended counterclaim to the cross claim of Florida Fiber, they basically bring a breach of contract action against Florida Fiber on the APA, which admits that there was consideration, because they say OTI Fiber has performed all of its obligations under the terms of the asset purchase agreement. Now, I do want to address briefly the Hill affidavit that counsel says was not properly made on personal knowledge and did not satisfy any sort of exception. We argue that under the Johnson case, which is cited actually in OTI's reply brief at page 12, they had an obligation to address any sort of evidentiary problem with the affidavit with the trial court. There was no objection to the Hill affidavit. And yes, we understand that our burden on summary judgment under the rule that was in effect at this time was to demonstrate the non-existence of a genuine issue of material fact, but that under the Johnson case at page 1211, this court's case, there's a discussion that all the de novo review that is employed on summary judgment is not a gateway to reach unpreserved legal arguments. And so I do want to point that out, because there is no transcript here. And even though typically a transcript is not needed in a summary judgment case, if there is a question of whether a legal argument was preserved, that is not always the case, or a challenge to an affidavit. Oh, I'm so sorry. The lights just went out in here. I hope you can see me.
You're
I
still-
don't know
you're
what
good. You're
happened.
still good. We see you.
Okay, now let me briefly get to the cross appeal. Is that appropriate for what we set up?
Sure, absolutely.
Okay, just very briefly, we argue that the court should reverse the order denying attorney's fees as a matter of law as well, because the court's ruling in the fee denial order that there was no privity of contract between Center State and OTI is inconsistent with its ruling in the summary judgment order regarding assumption. And there is case law, the Dennis case cited in my brief and the TA case that says that a summary judgment order cannot, a further order cannot be inconsistent with a summary judgment order. And like I said before, when I opened, 2.3a is not conditional as to what was assumed.
So, yeah, but yeah, you know, I'm confused now.
Okay.
You say that the judge denied the attorney's fees on the ground that you two parties were not in privity, correct?
Correct. That's what it states in the order.
So that to say that is inconsistent means that the first case was not a third-party beneficiary claim, correct? It was a claim based on privity of contract between the two of you.
Correct. And that's the claim that we made. That's what we pled. That's why we
But you did not plead a third-party beneficiary claim.
No, we did not.
You're saying today that if this was only a third-party beneficiary claim, you really should have lost.
Well, I'm not saying that. I didn't.
I know I put you on that spot there. I'm sorry.
That's
I shouldn't
okay.
have done
I'm not, we do agree. We do believe that we are a third-party beneficiary to the APA. However, that is not what the record ferrets out, because that is not the claim that we raised.
So you have somebody, you have OTI's signature on a note or a contract between you and OTI.
We do not.
Right. Isn't that what privity is about?
Not under the case law that I've cited before, the Banco case and the Bernard case from the Florida Supreme Court, is that a successor or, either through, which the note allows, by the way, the note allows that, it says that the obligations fall also on any sort of party that assumes or it's assigned to, et cetera, et cetera. And so although we don't have a document, I think you might.
There was no assignment here, and there was no agreement between OTI and your client to assume this obligation. No agreement, they could have assumed it, but they would come to you and assume it, but they haven't done that.
Right, they've assumed it through
An agreement with another party altogether.
Fiber. Correct, and they do argue on another note regarding the pendency of the cross claims, et cetera, et cetera. However, they've not brought the bank. The bank is out of the case. They've not added the bank as a party to those claims. And if that were the case as a practical matter, where you could prevent summary judgment in favor of a bank, infinity until your cross claims are decided, that isn't, respectfully, that's not what the law provides. And it's a final judgment as to the bank. So I don't think that the pendency of the cross claims has anything. This happens all the time, where, for example, a bank will get a judgment and then the guarantor and the borrower are left to fight it out, about who is going to pay. And so if the court has no further questions, we ask that the court affirm the entry of summary judgment in favor of Center State and reverse the order denying fees.
Okay, thank you, Ms. Fiore.
Thank you.
Mr. Wallen?
Thank you, Your Honor. I've got just a couple of things to say. I forgot to even address the fees issue. Paragraph 2.4b3 of the contract talks about what obligations were intended to be assumed. And it says, the outstanding balance owed as of the closing date in respect of the assumed obligations, which are approximately $340,000. The promise was to pay the balance owed, plain and simple. This wasn't like the guarantee in another case where it's signed at the same time as a note and they both reference each other and specifically, basically become incorporated in each other. This is an agreement at best, if the representations turn out to be true, to pay whatever that balance is, and that's it. There is no representation that we're assuming any other responsibilities under any of those loan documents. There isn't even any evidence in this record that we ever saw an attorney's fees provision in any loan document. There's just nothing. There's no proof that it was even provided to us. We can't have assumed an obligation to pay fees that we didn't even know about. And they just haven't proven it. They haven't proven that there's any assumption at all. So, in that regard, the trial court was absolutely correct. And that should be affirmed in the event that the main appeal is not reversed. Obviously, if the main appeal is reversed, then there's no entitlement to fees either. There was a lot of discussion about whether they filed a third, intended third-party beneficiary claim. They did not, and they've acknowledged it here. They acknowledged it on page 8 of their reply brief with regard to the fees appeal. They have to prove that they were what the intent was to benefit them. There's no evidence of that. There's no pleading of that. They just haven't proceeded on a viable claim. So for the reasons that I've discussed earlier, I respectfully submit that the main appeal, the summary judgment should be reversed. This case would be sent back to discovery as to the meaning and the intent of the APA in the event that Center State decides to replead their claim to appropriately assert a cause of action. There's certainly disputes of fact below and a serious risk of inconsistent judgments. And I think that wraps it up for me.
Okay, thank you both very much.
All right, thank you.
Oh, you still have, I'm sorry. I
That's
totally
okay.
forgot your rebuttal, your rebuttal, Ms. Fiore.
That's okay. I apologize. I just for speaking up. Two very quick things. So regarding just limited to the fees, again, I direct the court back to 2.3a, which says that OTI agreed to assume, pay, discharge, and perform the assumed obligation and liabilities. If you look at the provision counsel addressed the court's attention to, directed the court's attention to 2.4b, it says the outstanding balance, but it also says in subsection little I, it says as to another loan, it talks about the outstanding principal. So it knows the parties knew how to limit it to the principal. And if you look at record pages 231 and 257, the OTI was given copies of the bank documents, the loan documents. So it was on notice of the fee provisions. And I'd like to just again ask the court to affirm the summary judgment and reverse the fee order. Thank you.
Okay, thank you both very much. Thanks for your cooperation.